Hello, everyone, and welcome to today's episode of the Globe webinar series on the future of global governance. I'm Carrie Otterburn of the Leuven Center for Global Governance Studies, and I will be moderating today's discussion. Today, we are joined by Professor James Harrison and Professor Adrian Smith to discuss their new book, Free Trade Agreements and Global Labor Governance, the European Union's Trade Labor Linkage in a Value Chain World, co-authored with Liam Campling, Ben Richardson, and Mirela Barbu, and published this year by Routledge. Professor Adrian Smith is Deputy Vice Principal of Research Excellence, Dean for Research in the Faculty of Humanities and Social Sciences, and Professor of Human Geography at the Queen Mary University of London. Adrian's main research and teaching interests are in economic geography and international development, global production networks and international trade policy, economic security or rather insecurity, and the restructuring of industries in post-socialist East Central Europe and North Africa. Professor James Harrison is a professor in the School of Law at the University of Warwick. He is co-director of the Center for Human Rights in Practice. James's research is focused on the broader social and environmental impacts of economic laws, process, and actors, in addition to many non-traditional forms of regulation and the use of legal norms by non-governmental organizations. Also joining us today as discussant is Dr. Samantha Velluti. Samantha is reader in law at the School of Law, Politics, and Sociology at the University of Sussex. Her research focuses on EU governance, law, and constitutionalism, exploring the multifaceted roles of law and hybrid forms of regulation, particularly in relation to the place of human rights in EU legal contexts, examining key legislative developments and the judicial activism of the European courts to promote and protect fundamental human rights, both internally and externally. Her current areas of research include EU asylum law and policy and the promotion of human rights and international labor standards in EU external trade law and policy. We will begin today's webinar with a presentation by James and Adrian of about 25 minutes. Then Samantha will start off the discussion by offering her reflections and asking a few questions, and James and Adrian will have an opportunity to respond. Then we'll turn to questions from you, the audience. Feel free to send questions to me throughout the webinar by using the webinar chat box function on the side of the webinar window. I will collect your questions to share with the speakers following the presentation. Before we begin, just a few words about the GLOBE project. Funded by the European Commission's Horizon 2020 program, GLOBE seeks to understand the constraints and opportunities for the European Union in promoting its interests and values through global governance, with specific attention to four key areas: trade and development, security and migration, climate change, and global finance. The 3.5-year project aims to identify the major roadblocks to effective and coherent global governance by multiple stakeholders in a multipolar world, as well as to look ahead to 2030 and 2050 in order to equip policymakers with the tools they will need to deal with future challenges. On behalf of the GLOBE project, I would like to thank Adrian, James, and Samantha for joining us today. And now it is my great pleasure to give the floor to James.
Great, thanks, Carrie. Can you just let me know when you can see my screen?
Looks good.
Am I sharing it okay? Great, okay. So let me just, is that still there for you? Great.
That looks great.
Okay, so thank you very much, Carrie. We're very grateful to Axel Marks as well for inviting us to present our book in this excellent GLOBE webinar series alongside so many other wonderful books on global governance. We particularly welcome the invitation from Axel, as we see him very much as a fellow traveller and pioneer in the subject area of our book. Thanks also to Carrie for the kind introduction and for chairing the session, and to Samantha for agreeing to be the discussant. We're very much looking forward to what she has to say. So this is a talk about our book, Free Trade Agreements and Global Labour Governance, the European Union's Trade Labour Linkage in a Value Chain World. And you can see the book up on the slide there. So at the heart of the book is the issue of trade labour linkage. And what I mean by this is the consideration of the interests and rights of workers within trade policy-making processes. And we will go on to talk about the practice of that in EU trade policy in a moment. But first, let me tell you what you're in for in the next 25 or so minutes. So in this talk, we want to do three things, and we're going to tag team our way through it. So first, I will situate this book within the broader social sciences literature on the trade labour linkage and explain its importance in that context. Second, Adrian will explain the methodology developed for exploring the research questions we sought to investigate and what our key findings were. And finally, I will consider the implications of this for how we should think about the transnational regulation of trade and labour issues in the future. So first, situating the book in the broader scholarship. Now, in essence, this book is asking readers to re-engage with the issue of trade labour linkage and to conceptualise it very differently from the way in which it's been framed in previous social sciences scholarship. There have been two big debates about trade and labour you may have come across that still dominate the trade and labour literature. The first centred around a proposed social clause at the World Trade Organization. The social clause was proposed by developed countries and opposed by developing countries, and the scholarly debate was also framed very much in terms of developed versus developing country interests. With the rejection of this clause, much of the scholarly as well as political interest in the issue went away. Second, an important strand of international legal scholarship has framed labour as one of a series of non-trade issues, whose relationship to international trade law is the subject of much contestation. Against a backdrop of concerns about fragmentation in the international legal system, the main thrust of analyses has been to identify obligations arising from international trade law on the one hand, and international human rights law, international labour law, and environmental law on the other, and to work out how the two bodies of law could be made more coherent and consistent. In both of these debates, the influential scholarship on this issue took place around the turn of the millennium. Our book argues that it is now time to revisit this issue and to fundamentally rethink debates about trade labour linkage for a number of reasons. And I want to give you 4 key ones today. So firstly, trade labour linkage has moved on. From the 1990s onwards, states have included labour provisions in bilateral trade agreements outside of the World Trade Organization. Between 1994 and 2019, there were 85 trade agreements with labour provisions put in place, which together covered 138 national economies. So while for many years then, the notion of a trade labour linkage was discussed largely in hypothetical terms, it can now be considered practically as a way in which global labour governance is conducted. Second, trade labour linkage has previously been largely studied ahistorically. It was always misguided to restrict the history of trade labour linkage to the social clause debate in the WTO. In fact, there is a much longer and more nuanced history of attempts to use international trade policy to govern labour standards, which we chart in chapter 2 of the book, and relate to wider changes in global capitalism. I don't have time to explore that today, but these varied efforts demonstrate that geographical, geopolitical, and industrial contexts matter. They also point to a much broader range of possibilities for linkage in the future, and that efforts at trade labour linkage do not necessarily pit the global north against the global south. So third, trade labour linkage has tended to be studied by legal scholars like me as text on a page. So they are generally still asking, is there the right textual formulation of labour provisions in this trade agreement? There is generally no recognition of trade agreements as living instruments brought to life by the actions of state officials and other stakeholders tasked with their implementation. In fact, I think this is a problem with trade law scholarship generally. I recently looked at the last 5 years of trade law scholarship in 2 leading international economic law journals, and there were no articles over this period in either journal whose primary purpose was to investigate the effects of trade law obligations in the real world. Fourth and finally, trade labour linkage has largely been studied without considering the effects of trade on labour relations. So scholarship has largely ignored the fact that trade is meant to change how people work. Trade is, in many respects, about changing and reorganizing international divisions of labour, where things are produced, by whom and under what conditions. The scholarship has ignored this, even though the most divergent theories underpinning international trade law and policy agree that it does. So theories of comparative advantage and unequal exchange both envisage trade liberalisation, leading to a massive reorganisation of labour. Comparative advantage emphasises the mutual gains and even convergence between workers in different countries, while unequal exchange emphasizes how international trade and its regulation under global capitalism has produced international divergence and increased inequality. But existing scholarship in our field brackets out the effects of trade on labour, narrowly studying only the labour provisions themselves. In much of this scholarship, labour is even conceptualized as a non-trade issue, reinforcing the idea of market exchange as privileged, as an end in itself, and the social dislocation arising from this as accepted and unavoidable. For all of these reasons, we thought that new approaches to studying this issue were therefore needed, and here's where I hand over to Adrian to tell you about them.
Thanks, James. So what I want to do in this section of the talk is to talk through some of methodological approaches and how we sought to overcome the limitations that James has just mapped out in relation to the previous scholarship, as well as to highlight some of the key findings that we discuss in the book. Critical to our approach was firstly that it investigated the new forms of labour governance which have started appearing in international trade agreements. Second, our study was historically embedded in the particular employment relations and labour struggles taking place in trade agreement participant countries. Third, it involves studying trade agreements as, James mentioned, quote, living instruments, not just as black letter legal text, but as legal instruments which have effects and in turn shape the environments of work, for example, and employment in which they are deployed. And fourth, it examined trade labour linkage as part of what we term in the book the trade labour nexus, studying the effects of labour provisions alongside the effects of commercial provisions in the trade agreements on workers' lives. Now, a key way that we examined these relationships was through investigating the effects of the labour provisions, the trade labour linkage, within the context of some of the most important supply chains or value chains impacted by the trade agreements. This reflects an increasing awareness in value chain scholarship that the world economy is increasingly organized around globally integrated industries in which the various stages of production are increasingly disaggregated into different steps, often with very different economic geographies and working conditions embedded within them. And the trade agreements often fundamentally reshape these value chains by recreating new international divisions of labour. Can we have the next slide, please?
Sorry.
Thanks. So at the heart of this book, in chapters 3 to 5, we present case studies of our investigations into the European Union's free trade agreements in three contexts. Firstly, with CARIFORUM countries of the Caribbean, with a focus on Guyana. Secondly, in South Korea, and thirdly, in Moldova. We conducted several hundred interviews with key stakeholders in those countries, including government officials, trade union and business representatives, NGOs and academics, and reviewed many pages of documentary evidence. First, we examined the effects of the labour provisions in these trade agreements at a national level in these very different case study contexts. This analysis was accompanied by an exploration of the effects of labour provisions and the wider trade agreements in which those provisions are situated in relation to particular global value chains and their associated workplaces. And these are sugar in Guyana, automobiles in South Korea, and clothing in Moldova. We chose these value chains not to compare them between the three cases per se, but to use them to shed light on the extent to which the legal provisions are actually leading to meaningful change in the material economy, i.e. in key export sectors, most likely to be impacted by the trade agreements. There was this engagement with global value chains and trade policy and labour provisions that led us to work with scholars from several different disciplines. Colleagues in business schools, myself from economic geography, James with a background in law, and a colleague in politics. The value chains chosen reflected the expertise of the team and the key export sectors in each case study. Looking at the effects of free trade agreements on labour standards through a value chain lens is vital, we argue. There's a rich literature that has examined how cross-border power that transnational corporations or lead firms exercise in the value chain has conditioned labour standards and labour conditions among supplier firms. But this literature has paid very little attention to the role of free trade agreements in this process, especially as it relates to labour provisions. Our theoretical approach deployed the concept of the labour regime to investigate the complex interactions between free trade agreements and their labour provisions and global value chains, recognizing that different national, industrial and workplace contexts will create different outcomes when studying the effects of the free trade agreements. So what are the key findings of the book? Could we have the next slide, please, Jen? At the national level, we show how labour standards provisions were of relatively marginal importance in the negotiation and implementation of these agreements. We found that government officials from trade partner governments saw labour provisions as largely externally imposed by the EU and not necessarily their responsibility. Their focus was on more pressing and immediate concerns, including negotiating an adherence to the commercial provisions of the agreements. EU officials also had very little conception of their role with regard to labour provisions and very limited understanding of the dynamics of domestic labour struggles in trade partners countries, making them largely powerless to push for changes to domestic labour law and practice. At the same time, there was no sense that these provisions were intended to have any real effects on labour relations within the European Union. Could we have the next slide, please? So moving on to the global value chains, we examined the extent to which the labour provisions in our chosen free trade agreements had meaningful purchase on labour standards issues in each value chain. Our assumption was that if labour provisions are to have meaningful impacts on trade partners' labour standards, then we need to see the effects or purchase of these in key sectors. This analysis revealed that for workers across all of our export industries, the labour provisions were largely mismatched with their most pressing workplace concerns in all three cases. The labour provisions focused on alignment with ILO core labour standards, but the pressing labour issues were often quite different. And at the same time, some of these concerns were exacerbated by the agreement's commercial provisions. So, for example, in Guyana, where sugar comprised a significant export sector, approximately 43% of EU imports of sugar are from Guyana, and the sector accounted for about 10% of employment nationally, we found that closure of sugar estates in the country's single biggest employer was significantly influenced by changing trade relations with the EU and the associated downturn in sugar exports. This led to significant economic dislocation and political discontent. With its focus on niche export opportunities and appeals to social dialogue, the EU CARIFORUM Economic Partnership Agreement was simply unable to mitigate such trade-induced dynamics on this sector of the Guyanese workforce. And at the same time, the potential for economic and social upgrading as a result of the agreement was severely limited. Secondly, could we have the next slide, please, James? Thanks. In Korea, where automobile production represented around 17% of industrial employment, mostly in large conglomerates, the so-called chaebols, and constituted something like 16% of EU automobile imports, we found that the commercial provisions of the agreement shifted competitive conditions in the Korean auto market, contributing to an influx of imports from the EU and in particular from Germany, especially of larger cars. And the erosion, therefore, of, for example, Hyundai Motor Group's profits, with Hyundai being Korea's largest auto manufacturer. This threatened to create adverse impacts on workers in more insecure and low-paid jobs in the sector, especially those located in the lower tiers of the production network in Korea. And thirdly, in Moldova, where clothing exports account for 18% of manufacturing exports to the EU, and the sector employs around 20% of industrial workers, as tariff barriers were reduced, exports, particularly to the UK and Italy, increased. This created more jobs and sustained existing jobs in former state-owned enterprises in a workforce that consists of approximately 90% women. So there was a positive impact on female participation in the workforce, but commercial and cost pressures from lead firms in the UK and Italy, combined with weaknesses in the labour protection system in Moldova, also led to the entrenchment of poverty wages for workers, heavy reliance on piece rate payments, and the development of other troubling overtime practices and production methods. So overall then, we found that the labour standards provisions in EU FTAs were largely ineffective in protecting workers' rights and amplifying workers' voice. Moreover, there was some evidence that the wider free trade agreements had worsened employment prospects and jeopardized labour rights for workers in these three industries. There is, of course, one case where the panel of experts group used to adjudicate on disputes over the implementation of the labour provisions has been enacted, in part around non-progression of recognition of the remaining ILO conventions on core labour standards in South Korea. This took several years of sustained pressure from trade union, NGO and MEP groups after long-standing resistance from the European Commission to pursue the dispute settlement elements of the agreements. The process in turn has been delayed significantly, and the panel's judgment, which is itself non-binding, has yet to be made public. And I'm going to hand back now to James for the final part of the presentation.
So thanks, Adrian. So yeah, our third and final issue, what are the implications of this for how we should think about the regulation of trade and labour issues in the future? So there's a lot in the last chapter of the book on this, and I don't have time to address it all now, like for instance, the dangers of co-option for civil society actors institutionalized within trade governance mechanisms. So today I want to focus on three reimaginings that we see as critical to more progressive forms of trade labour linkage in the future. So first, a reimagining of the scholarship in this field. Second, a reimagining of the trade policy space. And third, a reimagining of the trade labour linkage. So as you've heard, our findings reveal the inadequacy of current efforts to address labour issues through trade agreements. I think they also point to the inadequacy of the traditional scholars' approach, and certainly when it comes to legal scholars like me, to researching these issues. By focusing on the adequacy or inadequacy of the text on the page, we inevitably also limit capacity to understand what should be done differently in the future. And so traditional analysis tends to end with an argument that labour provisions need more teeth or better enforcement. Our research identifies the importance of research into labour provisions in trade agreements being undertaken within a broader examination of the changes introduced by the commercial provisions of the FTA and the extent to which they filter down to the workplace, what we call the trade labour nexus. This kind of research reveals that the adoption of commercial obligations contained in trade agreements creates differentiated impacts in different national contexts and in highly differentiated GVCs, including sometimes serious negative impacts for workers. By exploring the reality of the differentiated outcomes for workers that trade agreements produce in different geopolitical, national and industrial settings, we are able to engage with broader debates about the action necessary to fundamentally reform not only trade labour linkage, but the broader trade labour nexus. And this brings me on to my second point about reimagining the trade policy space. In this context, we caution against a retreat by the labour movement into the national policy space, arguing this would face immediate challenges in dealing with GVCs that operate across multiple jurisdictions, as well as risking a reduction in transnational solidarity and a stoking of nationalist sentiment. We also caution against relying on the international fora, on other international fora, to adequately address issues related to the trade-labour nexus due to the inherent weakness of existing fora like the ILO and the likely limitations of future efforts such as the UN Treaty on Business and Human Rights. This is something I can perhaps say more about in discussion. So we argue against an evacuation of the trade space for addressing issues associated with the trade-labour nexus. Instead, we call for engagement in the project of reimagining that space. Most fundamentally, we call for rethinking of the language and actors of trade policy and argue for a paradigm shift in the very idea of what trade agreements are, including relabeling them as international cooperation agreements. This terminological change could have important discursive effects, challenging the assumption that the increased movement of goods and services ought to be valued for its own sake, and raising distributive questions about the costs and benefits of international exchange out of the ghetto of non-trade issues. Within a fundamentally reimagined trade regime, we then finally argue for a fundamentally reimagined trade-labour linkage. We call for a more internationalist form of linkage, which would mean considering ways in which the demander of labour standards, in our case the EU, ought to be subject to labour governance too. We also call for bespoke labour provisions for each national context. But for reasons of time, I'll focus on the final and most fundamental aspect of that reimagining here. And that is a shift from seeing trade agreements only as instruments of state-to-state governance and reconceptualizing them as instruments that can be utilized in the governance of GVCs. We argue that there is a strong rationale to use trade agreements to regulate those industries and workers that are tied into the value chains of firms who are benefiting from respective trade agreements, and to incentivize serious action to improve outcomes for workers in those GVCs, for instance, through joint liability agreements, binding agreements between buyers and suppliers, which oblige firms to improve working conditions and hold them accountable in instances where systematic rights violations or serious injury do occur. We end the book with this final line. Policymakers have continued to claim that trade can work for all. It is high time to make good on that promise. We believe that the kind of reimaginings we articulate in the final chapter of our book are ideas that should be taken seriously in efforts towards that end. I think we'll finish there.
Thank you very much to you both for this engaging presentation of these very compelling arguments and giving us an overview of your excellent book. And now I would like to give the floor to Samantha to kick off today's discussion. But before I do, I'd also like to remind the audience that the question and answer session will begin soon. And I invite you to send me your questions via the webinar chat box. You can see that at the bottom side of the webinar window. So please send your questions through there and I will read them out when we get to the Q&A section. Samantha, you have the floor.
Thank you. Well, I also want to start by thanking Axel Marx for inviting me here. I thoroughly enjoyed reading this book. I agree that it's an outstanding interdisciplinary book, particularly for the empirical contribution that it makes to labour standard provisions, and I really enjoyed the methodological approach, which highlights the mismatch between lived workers, the lived experience of workers and the core labour standards that EU's trade agreements try to promote. And the book really invites us to think about the limitations of EU social conditionality without, however, completely abandoning the potential that these agreements have. And I just wanted to highlight some of the things, the strengths of the book to start with, which sum up neatly what both James and Adrian were saying. In particular, the I like the thick notion of the trade-labor linkage that they examine throughout. So trying to sort of create a nexus, as they both say, between the trade and labor provisions, rather than examining the labor provisions in isolation. And that is particularly important for assessing what impact they actually have on workers. So this focus on the contextualization of the linkage, I think, is very important to take into account workers' lives. And as I mentioned, also another strength of the book is the labor regime concept and in particular the nested scales as they define them that refer to sort of different levels of analysis. So the state level, the industry level in particular, thus illustrating how important the context is. But I want to stress again also their reference to lived experience of workers and how, why they argue that there's a mismatch. And I entirely agree with that. So they refer to the importance of labor standards in practice, remuneration, including wages, pensions and incomes, job security, and availability of alternative employment, and representation, referring to workers' collective voice. And in this context, the centrality, as they stressed, of GVCs, of global value chain. So I think these are really strengths, methodological strengths of the book. But now my questions, rather than sort of focusing on specific aspects, are more reflections about the central argument, which is to depart from sort of a traditional approach limited to sort of a text analysis of the provisions and to focus on the effectiveness. And I quite haven't formulated them clearly in my head. So, but I think they can be summed up as sort of one being a more legal type of question and one having more political connotation. And I see them then as being interlinked. So my first sort of general reflection consideration is, which in part you have referred to as well, and I will mention some of the pages of the book which refer to this. One of the main limitations of these new free trade agreements is possibly the fact that they are state-centric, essentially. So even though they do envisage in the TSD chapters a tripartite structure, it doesn't go far enough. And what I mean by state-centric is, the fact I refer both to the sort of negotiation stage and the implementation stage. So problems of how they are conceived and then how they are then implemented. And on page 129 in your sort of methodological book, chapter, in fact, you refer to how the European Commission agenda of including labour standards provisions has been sort of follows pressure from the European Parliament, how state negotiators and EU trade partners focus on their own sort of narrow agendas, narrow interests, and then importantly the sort of difficult role that organised labour generally and other advocates of labour rights have in the the limited role in the negotiation process and then in the implementation process. So this already seems to suggest that, yes, the problem is a rather state-centric approach, also because of what you say about the importance of examining global value chains. And also where you refer specifically about the mismatches between the most pressing concerns that workers have and the core labor standards in the provisions. And also, again, something you referred to earlier, the fact that civil society mechanisms have been limited to date because they have been channeled. So quoting again your book on page 140, they have been channeled into structured dialogue that rarely produces meaningful results, something that I entirely agree with. And so on a more sort of provocative note, doesn't that then mean that we return to questions of legal design? So that is not to obviously dismiss the importance of examining the effectiveness of the agreements, but it could be that it is in the way they are designed, even content-wise, as you stress yourself also in the book, of departing from sort of a focus only on core labor standards. This could be the problem, one of legal design, also in relation to what you say about, for example, the EU's dispute resolution process. And this links to another sort of, again, more legal question, which is addressed also in the book, and that is the limited legal remedies that non-EU nationals have. So, you know, I'm going back to cases of the Court of Justice and the General Court in particular in the Mugabe case, said that each party to the agreement is free to decide whether there might be an infringement of, you know, clauses relating, you know, here specifically it was about fundamental human rights, not so much social clauses. But what is significant is the message that the General Court is giving, that is that the parties have discretionary power, and for that reason, the agreements cannot have direct effect. And this also then relates to the new generation of free trade agreements, because they now have clauses which specifically say, including the EU-Korea FTA, that they do not have direct effect. So even though, as I said, I agree entirely with the points and the arguments that you make, my point there would be, isn't it also about legal design? And I believe that could be tie in with what you say about reimagining, rethinking trade agreements. And my last point, and then I'll leave the floor to those who are following us, is, as I said, more of a political nature, which is something that that you also mention in the book, and that is the fact that even without considering the trade labor linkage, labor rights, international labor standards are per se very controversial and are politically charged. So if we look at the behavior of some member states, we see that they themselves do not really respect certain core labor standards. So in your book, on page 147, you refer in fact to the Committee of Experts on the Application of Conventions and Recommendations of the ILO, commenting on how certain countries, such as Germany, Ireland, Lithuania, and so on, have not been respecting certain core labor standards. And so somewhat cynically, my question is that reflected in the way that then the free trade agreements have been conceived? And again, quite cynically, is the inclusion of civil society in these new trade agreements somewhat a way of really not really going ahead with a meaningful protection of labor rights through trade? And then going back, to some arguments which you examine in your book, that they're just a legitimacy token for the EU to proceed with these agreements. Thank you.
So should we come in now, Carrie? Is that helpful?
Yeah, that would be great. Adrian,
shall I kick off and then hand it over to you afterwards? So thanks, Samantha. That's really great reflections. Really appreciate the time you've taken to examine the book and to come up with such thoughtful reflections on it. So maybe I'll just say a couple of things and then leave it to Adrian to add to that. So first issue about kind of legal design of the agreement. So I think you make a very good point that legal design is really important, and I think we probably wouldn't dispute that. I suppose the way that I would frame it is by saying that, and maybe just to clarify, that I think the problem comes when the legal analysis itself stops at just looking at the text on the page. So if we just analyze textual provisions and say, what does this model produce? Then, in a lot of the legal scholarship that I read and comes to the conclusion that what we need is stronger sanctions. And that because you look at the model, you look at the legal model, and you conclude that what the problem with this legal model is that it doesn't have teeth, and therefore if it gets teeth, that will be the solution. Whereas I think when you look at broaden the lens out to look at the trade labor nexus and the labor provisions within these trade agreements as trying to tackle those issues about the reorganization of labor that trade agreements produce, as we've talked about, and as you rightly commented on, that idea that we've said that there's a mismatch between those labor provisions and what the trade agreement is actually producing, you then, I think, broaden the lens to what you do as a result. And I think you're absolutely right to say that some of the solutions to those problems will be the legal design of the agreements. So you can envisage a legal design which takes seriously the idea of GVCs and brings in obligations which engage with those three GVCs into the agreement. You can envisage a legal design which empowers those civil society actors that you've talked about, that we find in the book are at the moment of marginal importance within the trade agreement. So I agree that legal design is part of the solution to the problem. I suppose the point I would want to stress is that I think, and this has come as a lawyer and having had the joy of working with Adrian and my colleagues for a number of years on this project, it's opened my eyes to the fact that a legal analysis of the problems won't give you the windows into those solutions by themselves. And just quickly on the second point you make, yeah, I mean the controversy of labour rights. I think it is it is a real issue, and I think that's something we raise in the book. And I didn't talk about in a lot of detail, but you've talked about particularly the role of civil society actors within those trade agreements. And I think there is a real need to scrutinise carefully what those civil society actors are actually achieving. And in the book, we raise some doubts about whether their presence within the agreement is sufficient to justify the actual what they're actually achieving in practice as a result of being there. And so I think we open that question up, and I think that's for others to kind of follow up and then scrutinize more carefully. Can I hand over to you, Adrian? Anything to add?
Yeah, thanks James, and thanks Samantha for the really helpful comments. They're really very good. So, and thanks for taking the time to look at the book. Yeah, I mean, I don't have too much more to add, and we may want to open it up, but just very briefly, I think that question of design that you've raised and that James has touched on is really important in terms of thinking through steps forward, but it's not going to be sufficient, because I think there is a kind of conceptual question as well, not just about how you design a legal text to deal in a free trade agreement, but if you want to take seriously the fact that fundamentally this involves the enactment of an organization of corporate practice across different jurisdictions or different geographical spaces, different economic geographies, if you like, then we have to bring kind of into the conceptual mixing at the outset the important role of private actors in all of this. So, some of the arguments that we make in the book around joint liability, for example, which is kind of all of those debates taken place outside of a thinking on trade agreements, really needs to be brought in much more front and center in terms of the conceptualization of what a trade agreement is hoping to do, both in terms of enabling deeper levels of economic integration, but at the same time dealing with some of the really challenging employment and working relations consequences of that deepening. And yeah, I mean, the final point that you made, and James touched on this, around the controversy, of course, of labour rights and the extent to which the trade and sustainable development chapters are really just a way of avoiding meaningful progress on this. I mean, I think that argument is well made and has been made by many critiques of labour provisions in trade agreements. And I think in the book we're sympathetic to that, but I think also recognizing that the fact that we've come this far in this journey does actually open up some, if you're thinking more expansively and perhaps more radically about the opportunities here, it does open up a space by which you can then think about next steps. So in the book, we deliberately didn't want to, if you like, throw out the baby with the bathwater and just throw up our hand and say, there's no way we can do anything here, and these are just not ineffectual mechanisms and tools, but to think quite carefully about, having got this far, what are the next things that we need to really do to make some meaningful change, which I think that kind of labour rights agenda is very much focused on. But I'll stop there, and Carrie, you may want to open this up. And thank you so much. That's really helpful.
Yeah.
Just coming quickly on that, and I think there you always have to look at the alternatives, and I touched on them briefly. What are the alternatives to trying to regulate these issues through trade agreements? And in the last chapter of the book, we do look at some of the the national alternatives, the other spaces of the ILO and the UN Treaty on Business and Human Rights, and we think those need to be weighed and balanced in thinking about what the ways forward on this issue are.
Yeah, can I just add one very quick thing? I mean, the point I wanted to make was that the empirical sort of study on the effectiveness can then feed into the legal design, which is something that you say, in fact, in the book. So my point was, rather than saying separate, that they can be, they can go hand in hand, and more empirical analysis needs to be made so that, for example, as you say, trade agreements can be tailored, the labor provisions can be tailored to the specific situation of a partner country. That's all. I don't want to take too much time.
We have several questions from the audience, so I will jump right in if that's okay. And I'll start with a couple of questions in the first round, and if we have time for another round, then we can go on to the second round. So the first question comes from Aureg Navasarshan, apologies if I get anyone's name wrong, who asks if bespoke labor provisions per national context might be a gateway to inconsistent policy. And relatedly, Wolfgang Pape asks, doesn't bilateralism's spaghetti bowl reduce the impact of the trade labor nexus that could be much stronger in omnilateral agreements involving all stakeholders? And then next we have a question from Jing Swen Wong.
Could you say, Carrie, could you just say that second one again, just so I've got...
Yes. Doesn't bilateralism's spaghetti bowl reduce the impact of the trade labor nexus that could be much stronger in omnilateral agreements involving all stakeholders? And then we have a question from Jing Swen Wang, who asks, to what extent is the evaluation and monitoring mechanisms important to the enforcement of the recommended labor protection policies, especially since you noted the huge discrepancy between compliance on paper and in practice? And I think just to wrap up this first round, we had two questions, but they were very related on the mandatory human rights due diligence that you briefly mentioned. One from Kingshu Bu and one from Laura White, wondering about how this possibility of mandatory human rights due diligence legislation and supply chains that's being drafted, how it might interact with the obligations on states articulated in the FTAs, with the direct obligations on the suppliers. So if you could comment a little bit more on your thoughts about that, that would be great. And then we can see about a second round.
Do you want to go first this time, Adrian?
Yeah, sure, I can do. Happy to. I'll pick up some of the points, and maybe James, you can you can hoover up anything that I might miss. So I think the first question was on how our argument around the need to identify what might be bespoke and context-specific labour issues might lead to inconsistencies across trade agreements. And I think, I mean, that point is well made. I think our argument is not that you simply go for a wholly contextual approach. There is something really important about the place, and we make this point in the book, the place that the ILO core labour standards have in the architecture of these agreements. There's something absolutely fundamental there as international labour rights, and those have to be central to any redesign of an architecture like this. But at the same time, the point that we make is that they're necessary, but they're not sufficient, because in terms of understanding the specific forms of interaction between a particular country, and in this case the EU, and the kinds of interactions economically that occur, one needs to have a more nuanced and granular understanding of the sectoral specificities and the particular working conditions and labour rights issues in those countries, in order to ensure that an agreement like this does have meaningful purchase, not just on legal provisions as established in the ILO core conventions, but in terms of also in terms of the core labour issues faced in particular in key export sectors. So it's not an either or argument that we make, and that might be one way to push back a little bit on the inconsistency argument. One of the other questions I think was around evaluation and monitoring, and the importance of that in terms of the meaningful implementation of these agreements. We haven't discussed that in any detail really today, but there, in various publications that we've written that came out of the project that led to the book, we have dealt with this extensively, and highlight some of the real limitations to the current ways in which evaluation and monitoring takes place. So, and that revolves around the extent to which the groups charged with, the advisory groups charged with monitoring, are sufficiently resourced, whether they are sufficiently reflective of the kinds of entities and interests that you need to do effective monitoring, and so on and so forth. And there are several different elements to the critique we make of the monitoring mechanisms, as well as some suggestions about how monitoring could be ramped up, could be made more robust and meaningful in terms of identifying the successes, but also the limitations of implementation of the agreements actually on the ground. But at the moment, the argument that we make very clearly, both in the book and elsewhere, is that the current architecture of monitoring is pretty limited in terms of its ability to identify key issues and to think through how one might begin to move more positively to their resolution. James, do you want to pick up on any of the other points?
Yeah, sure. So first of all, on the bilateralism question, so I think, one of the issues to say is that I suppose that trade agreements, bilateral trade agreements, are a very big phenomena in the world of trade. And so a lot of trade is occurring around the world through these trade agreements. And so we can't ignore that when it comes to thinking about the labor issues. So there is a degree to which I agree completely with, I think, with the questioner's position, which is that multilateralism may well be more effective in to some degree. And in an ideal world, you would have a global system in which you were thinking about GVCs and thinking about the kind of public international law which you might engage to do something about that. But given the importance of these trade agreements and the trade that they cover, and I think you have to think about the governance, them as a governance mechanism, and take it seriously, and think about the work-related issues that those trade agreements give rise to. You can't ignore them, but I think there are ways in which, too complex to go into now, but I think there are ways in which, if those labour provisions around GVCs are designed appropriately, they can begin to be jigsaw pieces of a global regime rather than strands of spaghetti that aren't building one on the other. So I think that's coming back to Samantha's point about a legal design issue that we need to take very seriously if we're going to get that governance issue right. And then the second question I think that Adrian left for me was around human rights due diligence and supply chains. So I agree there, absolutely. I think there is a real potential for those, for that governance issue to interact with what's happening in trade agreements. And the proposals for mandatory due diligence could be being picked up and could become something that trade agreements are creating meaningful obligations in relation to. I think there are two issues that need to be taken very seriously there. Is what would be a meaningful obligation in a trade agreement that would actually reinforce in a meaningful sense those human rights due diligence obligations. So if we look at the CSR obligations that we find in trade agreements at the moment, I think there are big questions about whether those in practice actually achieve anything meaningful. And so we would have to look very carefully at what those human rights due diligence obligations in trade agreements would look like, their legal design to be meaningful. And secondly, just more fundamentally about human rights due diligence, I think one of the kind of underexplored issues is there needs to be a conversation there about what is actually happening when companies do human rights due diligence. So I just have myself, and this is a slightly separate issue, but some concerns about this concept that's bandied around and everyone thinks they know what they mean. But for a multinational corporation to do human rights due diligence of all its operations globally is an endeavor that I think we haven't really understood properly. And so there's a danger that that can end up being superficial as a result. So we need to make sure that these building blocks, these pieces in trying to create value chains that are more respectful of labor standards are actually working in the way that we would want them to.
Thank you very much. I don't know if we have time for one or two more questions. Looks like we better wrap up. It is now 4 o'clock Central Time, but I can pass along some of the additional questions that we received to you via email. And if you care to follow up, I can arrange for that. And that is more or less all that we have time for today. But I would like to thank all of you, our speakers, Professor Adrian Smith, Professor James Harrison, and Dr. Samantha Velluti, as well as all of you, our audience, for taking part in this webinar. Before leaving you, I would like to announce that the Globe webinar series will continue next month on the 10th of December, featuring Stefan Renkens on his new book, Private Governance and Public Authority, Regulating Sustainability in a Global Economy. And you can register for that webinar and check out the rest of our winter and spring lineup online at globe-project.eu. And you can also watch all of the previous episodes of the Globe webinar series, as well as check out our publications and blogs. Thank you for joining us today, and we hope to see you again soon. From all of us at the Globe Project, thank you and goodbye.
Thank you very much.
Thank you.